right here, and then after that, we'll turn to the DCI panel since you have 3 people. Excellent. All right, thank you very much. Mr. Spears, whenever you're ready.
How you doing, Councilman Allen? Today, my name, again, is my name is Leon Spears. I'm speaking on behalf of dcConcealedCarry.com. Again, thank you for the opportunity to testify on these items. I hope my testimony today will provide unique clarification on the aforementioned bills and proposals of discussion. By way of background, I'm a registered District of Columbia firearms owner. I was issued by Metropolitan Police Department the very first concealed carry permit in the city, and I'm authorized by numerous police agencies across the country to carry a concealed handgun in 41 states. I'm currently an MPD licensed concealed carry instructor, a Maryland State Police qualified licensed handgun instructor, and currently hold NRA law enforcement instructor certifications in specific categories of handgun, shotgun, and patrol rifle. Additionally, I am a law enforcement instructor in the use of non-lethal weaponry, specifically Olean Resin Capsicum and Tactical Baton. I have taught more than 50% of the persons who have applied for and or received licenses issued by a Metropolitan Police Department to carry a concealed handgun in the District of Columbia. My educational background is in emergency preparedness, critical care nursing, and risk management. For the past 10 years, I've averaged more than 1,000 hours each year on firing ranges while conducting law enforcement shooting qualifications and or training. Furthermore, I am an expert on use of force engagement and threat assessment. As the owner and operator of dcConcealedCarry.com, I have had the humbling pleasure to empower law-abiding citizens with knowledge on the safe and proper handling and use of a concealed carry handgun in DC. Due to the district's special characteristics, applicants must be trained on sensitive places, situational awareness, and self-defense laws specific to Washington, D.C. I would highly suggest Chairman Middleton, as well as all members of this committee, to visit our office and see how the currently instituted policies are improving individuals' lives, not only in Washington, but across the country. Without further delay, here are my positions on the matters at hand. For Bill 22-0193, Temporary Protection Order Firearm Relinquishment Amendment Act of 2017, the good. On face value, this bill does something that sounds decent, requires an individual subject to the temporary protection order to relinquish his or her firearms. If the situation is truly dire, MPD should be intimately engaged already. The bad, lacking a clear and distinct process of how to examine the validity of the acquisition prior to relinquishing someone's constitutional right will lead to robust, improper implementation. This bill would allow retaliation and or other reasons other than personal protection of the applicant to use, again, without the opportunity of appropriate due process for an accused individual. My position, the council should not pass this bill. A court should issue an order during a final protection order hearing and afford all parties appropriate due process. Due to the temporary status, these orders would require quick and implementation, and the resources of MPD would become inundated with cases to process. Bill 22-0400, Extreme Risk Civil Protection Order Amendment Act of 2017, the good. Again, on face value, this bill does something that sounds decent, immediately allows MPD to take possession of firearms owned by the accused. The bad, lacking guidance where, at a minimum, the bill does not provide the making of good and substantial reason or a showing of good cause prior to MPD being allowed to enter one's property is profound. My position, the council should not pass this bill. Currently, there is no provision in the bill where any rationale be provided prior to the invasion of someone's property rights. The lack of poor direction of the use of law enforcement agency without any mandated notification is too far-reaching. Moreover, the bill states that the act alone of purchasing ammunition is an indication of increased risk of violence is, again, too far-reaching. There is no process of background checks prior to the purchase of ammunition. The first action does not guarantee the second action. Furthermore, the real-world operation means of securing someone's ammunition in many circumstances would unduly burden the MPD. Lastly, 220588, Possession of Firearm and Ammunition Penalties Amendment Act of 2017. The good, again, on face value, the bill does something that sounds decent. Harshly penalizes an individual with a desire to do mass harm to the public by eliminating his or her ability to unleash violence on the public with fewer, quote-unquote, high-capacity devices. The bad, the financial burden placed on law-abiding citizens to make significant purchases to update their magazines would be in the hundreds, if not thousands of dollars. Furthermore, some firearm manufacturers do not make magazines with a limited capacity of 10 or less capacity for their firearms. Currently, is it a misdemeanor to possess a high-capacity magazine, a penalty equivalent to illegally possessing an unregistered firearm in the District of Columbia. The sole act of possessing a magazine should not be increased to a felony for otherwise law-abiding citizens. Moreover, a violation of this nature would mean that all Second Amendment rights would be stripped from this individual based on the current federal law. My position is the council should not pass this bill. Washington, D.C. is a place where many citizens either pass through daily or make visit of a once-in-a-lifetime excursion. The possession of a magazine that does not purport to the district standards is incredibly harsh. This council could punish persons that have displayed multiple violations of possessing unauthorized devices differently. And the proposals 220552
Mr. Spears?
sent to the council. Yes.
Since we're a little bit over time already, and I know you've got 2 more resolutions, could you help summarize those 2? And of course, we'll have your full, your full testimony included as part of
Sure,
the
absolutely. The face of both the 0552 as well as 0796 are good value. But the bad is the actual firearm is not the issue, and the person's behavior is the issue. Furthermore, persons within a nefarious intent is the issue. How other states regulate its residents' firearm purchases and possession orders should be tailored to the legislative landscape and customs. And one other last comment in terms of the possession. I believe the person should not be in violation while in a city if he has been properly trained. There's no provision currently that dictates a reciprocity agreement with any state currently. This could be easily corrected. The council could oppose this resolution, and training for paramount if parties are all beneficial. DC could review states' training requirements and regulations and make determinations on who would be authorized to conceal carry in the city.
Okay.